Good afternoon and welcome to today's presentation, Employee Privacy Issues and E-Surveillance Practices. The information presented by the expert is not to be used as legal advice and does not indicate a working relationship with the expert. All materials obtained from this presentation are merely for educational purposes and should not be used in a court of law since the expert's consent, i.e. a business relationship where she or he is hired for your particular case. In today's webinar, Tim Dimoff will discuss what is e-surveillance, why use electronic surveillance, legal issues, what a company cannot do, and why would an employee investigation fail. To give you a little background about our presenter, Tim Dimoff is the founder and president of SACS Consulting Investigative Services, Incorporated, which is considered one of the nation's leading authorities in high-risk workplace and human resource issues, security, vulnerability, assessment, and crime. He is known as a speaker, trainer, investigator, and author, and has appeared on national radio and television shows and major newspapers. Tim is a nationally recognized expert of violent behavior and criminal investigation and has provided crime commentary and profiling analysis and has appeared on shows such as MSNBC, CNN, and Court TV. His expertise includes high-risk and security issues, human resource issues, corporate investigations, liability issues from hiring to firing, drugs and substance abuse, identity theft, law enforcement procedures, and victim justice. He has testified as an expert witness in many trials throughout his career. Attendees who require a passcode, the word for today is privacy. During the Q&A session, we ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you're applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes of this presentation. You're also required to complete a survey at the end of the program. Please note that CLE credit cannot be given to those watching together on a single computer. Tomorrow morning, we will send out an email with the link to the archive recording of the webinar. The slides can be downloaded from the resource list at the widget at the bottom of your screen. Thank you all for attending today, and Tim, the presentation is now turned over to you.
Thank you, Rochelle. And depending on where you are here in the country, good morning or good afternoon, and thanks for participating. This is a very hot topic, a very engaging topic, and we will have three sections, three slides, where we'll take some Q&A as we're going on this, so you'll have plenty of time to ask questions. I encourage questions, and you can even write the questions ahead of time in the chat box, etc. A little bit more on my background, just so you understand. I did spend 20 years in law enforcement with the Akron, Ohio Police and then the Federal Task Force. Much of that involved, majority of my years were with narcotics and the Federal Narcotics Task Force. Where obviously electronics, eavesdropping, wiretaps, and that kind of thing happen. And the basis of this presentation is you're going to see the fact that it really is going to be logged in, or the basis of it is going to be really goes all the way back to the electronic laws, the federal laws. And also I want to remind you, you have the federal electronic laws, but you also have state laws, and some of those vary, so we'll have to be conscious of that, and you'll need to check with your legal team and experts on that as you are dealing with those issues. I can answer a lot of questions. Once again, I'm not an attorney, and this is not legal advice, but this is some really good basic guidance, and I can answer a lot of questions and give you some feedback. So, employee privacy issues, e-surveillance practices. If there's anything happening, it's a very much increase in questions coming to my company and other experts across the country on what can a company basically do within the workforce as far as electronics surveillance goes. You know, cameras, taking pictures, videos, are you allowed to record sound, and where can you do it, where can you not, etc. Once again, I want to stress, every state has different types of levels, so be conscious of what your state laws are. What is e-surveillance? It's the acquisition of information. by an electronic, mechanical, or other surveillance device for any content of any communication without the consent of either party but legally permissible under state or federal guidelines. And basically, we're going to get into all these parts and pieces. So, close to 80% of companies admit to some form of monitoring employees. Now, some monitor the email, some do the internet, some do phone recordings, some do it all. And anytime this is going on and you have monitoring going on, and most of the time companies are making their employees aware of it. Also, all employees should understand that if it is company-owned equipment, phones, cell phones, cars, vehicles, etc., there should be a presumption that you don't have a privacy because it belongs to the company. And we'll get more into that, but it can happen. And that includes your emails and your computers and your cell phones and your laptops and your Surface Pros, and I can go on. So be aware of the fact, the first thing is if the company owns that product, many times it has a lot more levity in what it can do. So why are we seeing an increase in electronic monitoring? The reason is simple. We are seeing, in the eyes of the employer, a tremendous amount of what they call non-productive or downtime to their company by employees. By and large, companies are seeing through monitoring, through surveys, etc., that the productivity time is down, and a lot of it is connected to electronic devices and other reasons which we'll get into. So the main argument for electronic surveillance or monitoring is twofold: productivity, and then, of course, security, and thirdly, safety. So theft is a big issue, and security is another. So you're going to see those three, productivity, security, and safety, really being the cornerstone. Productivity is a primary concern for employers who feel their employees are bringing too much of their personal lives to work. How much are they bringing? Unbelievable. Surveys and monitoring that is done is revealing that the workforce is a much more entitlement-minded type of employees. Doesn't mean it's totally bad, but the employees feel that they can are entitled to much more downtime, personal time, and we're seeing an average of 2.5 hours per day reference downtime, meaning employees spending an average of 2.5 hours a day on their personal devices doing personal communication, sending photos, communicating with family members, friends, spouses, etc., their kids, and that has gotten to be quite a number, 2.5 hours as an average. The number of investigations using surveillance is absolutely increasing substantially. It can be very accurate. It can be a saver of cost, and it's a lot more defensible in court to have some type of electronic device supporting your investigation. So why use electronic surveillance? What's the big deal? Why should we? What can we gain from it, etc.? So let's get into that a little bit. Once again, you have different types of surveillance. CCTV is similar to the picture you see in front of you. It's basically a camera out in the open, no secret, no pinhole type camera. It's a camera that's out in the open, and it's for a reason. They want people to know that they have cameras inside and or outside of their facility. And CCTV is very good for safety and security, when you're working odd hours or late hours, for preventing thefts. A lot of basic good reason to have surveillance. The other thing is, in case something happens, you can then go back into the CCTV cameras and the savings of that through the computers and the digital format. The old analog is pretty well out. Then you have legal wiretapping. Yeah, basically you're talking about phones, and you'll notice on phones, if they're going to record you, you always are going to get that recording, that message at the beginning that your phone message could be recorded, blah, blah, blah. And basic cameras can be outward cameras, and they can be pinhole. And then your digital video equipment is obviously for taking videos of action, and you can have sensors or motion detectors to turn them on and off, or they can go constant. So we're here today to talk about pros and cons, lots of discussion on that, and this is a debate that will probably never, everybody will probably never totally agree on. I think most people agree that some form or limited use of surveillance is acceptable, and most people say it's very much more acceptable as long as people, employees, are being notified, or there are signs letting them know what's going on. And of course, there are needs for covert surveillance when you're having situations, problems, threats, or you're trying to protect something, and so we can go from there. All right, positive use in the workplace. Monitoring of the internet usage for appropriate work protocols. There's a tremendous amount of internet use for shopping. The two biggest, believe it or not, the two biggest uses of the internet in the workplace for personal reasons is shopping, is along with pornography. So shopping and pornography viewing at work is the number one and number two for utilizing, or for workers or employees going off base, non-work viewing. Those are the top two. And of course, that's a productivity issue along with other concerns. So a company would argue monitoring has its value. Productivity issues come into play. You even have computer systems and software that can all right, I'm getting a thing here that we're still on the first slide, and I am showing that I am on slide number 18. 1 second here while we try to fix this.
Hi, Tim, it's Rochelle. I just updated it, so you can just continue, and I'll just change the slides for you.
Okay, so, all right, thank you. Sorry about that, everybody. We're having some technical difficulty here, unfortunately. All right, hang on 1 second here. And let me see if this works to make it go. I'm going to go back one slide here a second. Tell me if it changed back to the pros and cons. Rochelle, did it change back?
No, not on our end.
Okay. All right. We're on slide 18. Inappropriate location issues. Are people going to inappropriate locations, areas that they don't belong in or should not go? Also, the positive is to monitor or prove workplace harassment, bullying, sexual harassment, violence, any of that kind of stuff. So a company feels there's a lot of positive from that, and also the positive to produce email and web records to defend against lawsuits. All right, we'll go to the next slide. The cons. Affects relationship between employer and employee. This seems to be the largest type of negativity, or one of the larger ones, where it just doesn't seem right. It seems almost creepy or non-trustworthy, and it can sometimes really diminish the relationship. And you want a positive work culture, and you want that culture to foster trust. And sometimes this can cause a negative feeling. And then the last cons is employee privacy. A lot of employees don't want to be monitored or micro-watched on everything that they're doing and where they're going, and etc. So the cons of this causes a tremendous amount of problems. And I would say the cons is the biggest thing is the workplace culture, the fostering of trust, the deterioration of that relationship. Next, slide 20. Let's consider whether the surveillance impairs trust or affects relationships. And once again, this slide shows that this is huge. Surveillance, too much surveillance. And as I said before, I think most of us are okay with a limited amount of surveillance, and it depends on how much and for what reasons and where, and those type of things. Once again, it affects the culture. Email, slide 21, 24% of the employers have had email subpoenaed by courts. So you can understand why they want to monitor. We're talking almost 1/4 of employers have had email subpoena. Many companies are finding, this is a new challenge. And they're battling workplace lawsuits. And why? Because it's triggered by improper, negative, defaming type of emails that comes from employees. And that's one reason why you see a lot more emails that are monitored by the company. All right, we're going to go to the first Q&A, and I'm going to look or ask for any questions that are out there. And let me switch over and look onto the monitor. If you have a question, please go ahead and post it. And Rochelle, go ahead.
Okay. I was just going to ask all the attendees can enter in the passcode for today, which is privacy, and any questions that you might have for Tim. And then I am sending you over the first question.
Okay. All right. First question. When you said at the top 2 employee uses of the computer are shopping and porn, yeah. My correction, that's the top 2 non-business uses for the workplace. I apologize for that. And it's the top 2 non-productive, non-company issues. Those statistics come from Society of Human Resources and other monitoring organizations similar to SHRM that come out, and they constantly employers are complaining about, non-workplace or non-work use of the internet. And what other things they're doing with that too is what they're doing is they're putting software programs into computers that prevents people from being able to go to off-sites of shopping, pornography, and others. And they're having a lot more success with limiting the sources or where they can go on the internet. Also, they're monitoring the internet, and they can get a printout of every location that you've gone to, and then they can address that confidentially one-on-one. Another question, do you see differences in monitoring frequency between private and public companies? Yeah, we're seeing probably more monitoring or more variety of monitoring probably on the private companies, where the public companies are dealing with a little more restrictions of what they're doing, and where the private companies feel it's their company, they own it, where they feel a greater need or desire, or that they should have the ability to monitor it since it's a private company. But we're seeing an increase overall in both areas, but I would say definitely private is definitely more than the public. How do you spot an undercover pinhole and hidden camera? That's a good question. Pinhole cameras are not easy to spot. I mean, when we get into electronic debugging in that, it takes a lot of sophisticated type of equipment. We have equipment that monitors or detects a signal, and we're going on that type of equipment that would be able to pick up a signal in that room. That's going to be your best bet, is using other electronic equipment to pick up the signals. The equipment is not real cheap, and it's not that simple to use, but it's becoming more and more. The cost is coming down, and monitoring and the use of it is becoming easier. So what kind of disclosures, is the next question, if any, are required for an employer to conduct surveillance? Well, if we're talking about different types of surveillance, let's go with in the building surveillance. If a camera system, basically for a private, is they're putting cameras in to monitor employee action. Technically, in most states, I won't say all, but in most states, they do not have to notify the employees that they have cameras in there and that they're monitoring. Now, that's just for pictures or video. If they are going to try to capture voice, that's a whole different ball game. And voice, some states won't allow it. Others say that you have to notify all the employees that voice is being utilized or captured. So it's real simple. You're taking photos or videos with no sound. You can pretty much, in most states, they allow that without notification. Some states allow it with notification. But if you add capturing sound or conversation, most states, that's getting into the federal, almost like wiretapping or electronic surveillance, and that becomes more difficult. And once you add capturing voice, notification is absolutely, I don't know of any state that allows it where you don't have to notify the employees of that type of action. So most companies stick to photos or video only, and they stay away from sound. The only exception to that is when do phone recordings, and you always hear a nice tape recording of how you're going to be recorded, and it could be used for this or this or that. So we go from there. Another question, do you see differences in monitoring frequencies between private and public companies? Okay, I think we answered that. We saw more of it in the private side, and we're seeing an increase in both. Question, do employees have rights, any rights, when the surveillance cameras were installed prior to informing the staff? And when the camera feed is not monitored by an outside source but a higher up in the company. Basically, you're going to go back to the basics, and the basics are monitoring visual only, very few requirements, in many cases no requirements to even notify in most states. So monitoring, there's very little requirements. Once again, where the employee rights really come into play is when you start to record conversation or sound. There are exceptions, such as you cannot put cameras of any sort in bathrooms, changing rooms, privacy rooms, breastfeeding rooms, anything of that nature. No form of camera is allowed in those rooms. So there are exceptions to which types of rooms, but for the most part, the public access of buildings or businesses, cameras are pretty much allowed and will continue to be in that mode. Okay, we're going to move on to slide 23. We've already talked about some of this. It says, what is legal? Wiretapping requires a wiretap order like a warrant, or it's illegal. If you're going to basically monitor or eavesdrop in on a phone conversation, that is wiretapping. That is basically, as it says in this slide, you need a legal reason and permission to do it. Now, could be a crime involved and you're working with the police and you're monitoring something going on at the workplace that is criminal. You obviously would have to work with legal authorities on that. Once again, if you're going to record anything on the phone, it's got to have that tape recording on it that notifies the person that they could be recorded. If employees' phones are monitored, they need to know, they need to be notified, and I would notify them in writing. I would not do it verbally, that their phones could be monitored at any time. Total. If you're going to listen in, you need to have total notification for each and every employee that it would potentially involve. Okay. Fourth Amendment rights on this slide 25. Protect citizens' privacy rights for situations in which persons have a legitimate expectation of privacy. Okay, once again, we're going to talk about bugging a phone, okay? Bugging, whatever you want to call it, but recording a phone conversation, is protected under the Fourth Amendment. And once again, if you're going to do it, you got to notify the person or persons on that phone. Now, is there a little more leeway in a public place than in a private place? Well, sure. There is no expectation of privacy in standing outside the front of a building, in the lobby of a building, of a restaurant, a bar, sitting at a booth, at a bar, at a restaurant. Those type of things, there's no expectancy of privacy for that type of thing. We have a new restaurant here in Ohio, and they're putting in these restaurants in these convention or meeting areas. They're putting in these new soundproof booths. So you're out in the midst of everybody talking and laughing and eating and drinking and doing whatever. And there should be no expectancy of privacy there. But let's just say you decide to get a phone call and you go to what we call a soundproof booth that's got the room, a little chair in it with a small table, and you can shut the door, and you totally are blocking the sound off from the general area. That booth would be a good example of you could not be putting a listening device in there and saying that it's public. You were in a public place and you went to an expectancy of privacy. So those are the kind of things that we're going to be debating. Workplace privacy issues and employee rights. Once again, it's simple. Camera use without sound, you pretty much in all the states. Some vary a little bit, but pretty much cameras in the business, whatever, are going to be, it's going to be a weak challenge. You add sound capturing, now you got a whole different ball game. Phones, we've already talked about it. You got to be notified on that. And the recording devices, let me point something out about recording devices. In Ohio, if I have a conversation with you here in my office, and I want to have a recording device turned on, sitting on top of one of my counters, in my pocket, I want to have my phone on, and I want to record our conversation. Okay, if you're in Ohio and Tim Dimoff is talking to you one-on-one, and I'm part of the conversation, I can record your conversation with me, and I do not have to tell you that I'm recording. It's called a one-party recording requirement, meaning if I'm talking to you and I'm part of the conversation, I do not need to tell you I'm recording you. In many states, it's called a two-party requirement. By that, it means I'm recording you, and both of us need to know it's being recorded. So the person speaking and the person who's talking to that individual. Many states have two-party requirements for recording, and many of them have one-party. I can tell you Ohio is a one-party conversation state. A state like California, I believe, is a two-party state for recording devices. So that's another issue that, is out there that you need to know, but that's specific to your state. Okay, slide 27. If you monitor, should you let employees know? I'm of the opinion if you're monitoring for general safety, security, productivity, day-to-day, daily purposes, my opinion, and it's not a universal legal opinion, and I'm not an attorney, my opinion is I would let the employees know. I would explain to them why you're doing it and that it is taking place. Now, if you're doing an investigation and you've got someone stealing tools out of a tool room and you put a pinhole camera in there and you're doing it because you've had an excessive amount of theft, then that's different. If it's for an investigation purpose or a security or safety, someone's being reckless or threatening or saying certain things to certain people, sexual harassment, if you're doing it as part of an investigation, then I think that changes the ball game, and I don't think you should obviously want to have to notify employees because that would probably interfere and make the investigation not a successful investigation. Vehicle GPS tracking, a lot of companies have GPS tracking on their company vehicles. Once again, I will tell you that if the company owns the vehicle, they have all the right in the world to put a GPS tracking on it. Do you have to notify the employee of the GPS tracking? Once again, you got to go back to state laws. A lot of states do not require you to tell the person that there's a GPS tracker on their vehicle. Now, reason for that is that expectation is not there by the employee because it is not their vehicle. So then the question comes up, well, what happens if an employee uses their vehicle for work and driving around, but it belongs to the employee and it does not belong to the employer, but they use their vehicle for work purposes? And let's even make it more unique. They're paid mileage, which means the company is paying for the mileage. Basically, if you're using your personal vehicle for work purposes, that does not automatically give the company the right or ability to put a GPS tracking device on that car without the knowledge of the owner of the vehicle. I would think, I do not know of a state that does not require a company to notify them, and not only notify them, but get permission. And sometimes the employee will give them full permission, they don't care. Other times they do not want the GPS tracking on at all, and whoever owns that vehicle is going to have the last say in whether it's on or off. There are companies that will have preliminary information or contractual agreements before they hire people, stipulating certain things such as GPS tracking on your personal vehicle for, the working purposes. But that's almost a contractual thing that needs to be agreed upon before you hire the person, because doing it after only does damage the culture, the trust, and it really can be a negative force with the company. So in most cases, if not all, where GPS is on personal vehicles, it's usually voluntarily done. Once again, monitoring emails, there's no big expectation of privacy if it's a company-issued computer at their desk, a laptop, even a company-issued phone. If the company owns it, it's a different ball game than if the company does not own that laptop and whatever. And even though you might be using it for work, it still enters into a gray area and makes it more difficult for monitoring. So the big universal is if the company owns it, the company issues it, you're going to have a lot more flexibility on all these issues that we've been talking. Slide 28. New technology makes surveillance easier. Well, it sure does. As I told you before, we now have abilities with software to stop people from going to shopping and pornography sites. We can put apps on phones, computers, everything to track and monitor. We have ability with software to print out lists of everything that you've done with that electronic device, to track web browsing activity, tracking keystrokes, etc. And now there's a new type of monitoring that software, believe it or not, it will actually track how long you are sitting at your desk using that computer and using it for work purposes. So now they have time trackers on the computers at your workstation, and it will tell them how many minutes or hours a day you were up from that seat and you went somewhere else. And once again, this is a work productivity type of new monitoring ability, and it's being received by employees with obvious mixed reviews. And then think about time spent at the computer, work activity, starting to be factored into how much money you make or bonuses or whatever. So I can see this is going to get, for lack of a better description, a little bit ugly, I believe, as we go into the future. Slide 29, the proverbial, they're watching Big Brother. Crossover takes photos of workers via webcam every 10 minutes. That's kind of attaches itself to what I was just talking to you about, monitoring how long you're at your desk. Another product, CumRAM, monitors all activities on all employee devices. We're getting to the point where there could be a virtual connection of each employee to virtually all their electronic devices that the company provides them to monitor the entire day when they walk in to the workplace and they're automatically starting to be monitored of what they're doing, who they're talking to, what sites they're going to, all totally from monitoring and being able to help improve productivity and decrease downtime or wasted time going to sites, communications with others that are non-work productive. So we're entering an era of what they would call the workplace big brother. Slide 30, employees have no expectation of privacy in connection to data stored in devices owned by the employer. I have this in big, bold letters, and the reason is obvious. I think employees need to understand absolutely zero expectation of privacy on any of the devices that are owned by the employer, any of the devices that you utilize, anywhere that you are working for the company, at your desk, etc. All that is going to be more and more monitored, and the expectation of privacy when you're connected and working with company-owned devices should be zero expectation of privacy. And I do not see us candy coating this in any other direction except that we know it. And on the flip side, once we understand and know that, it is amazingly a lot of employees are having very little difficulty working. The key here is employees that are being monitored day-to-day devices that is just regular routine work and they never knew it. That causes the biggest problem. So once again, does the employer have to tell you all that, devices and that? No, but are we finding out that it works a lot better culture? Productivity does go up, and the culture mood is more positive if basically employees are told and they're informed. Once again, it's a trust factor in many cases from the interviews that we've conducted. What can you do individually? Obviously, gather your information. It's listed here individually. You can gather addresses, all this list, businesses, education, employment history, family history, property holdings, marriages and divorce. This list is amazing because I don't know if everybody understands this is public access information. I put it here to give you an example of stuff that can be accessed. And this entire list here, I do not need any permission to gather this information. Okay? This is publicly accessible. It's a sample of 6 areas that maybe you thought you needed to get permission, but it's an example of no, we don't, and that this and much more can be obtained. So let's talk on slide 32, what a company cannot do. What can they not do? All right, this is important, and I think a lot of people today are probably listening to this webinar and watching it because of this slide. What can a company not do? What should they not do? And what can they not do is very important. Okay, as we said before, recording a conversation. It's very difficult. Different states, different laws. Ohio, 1-person recording requirement. Other states, 2-person requirement. Okay? Does the one party have knowledge? You're in good shape in certain states. Others, you're in violation. Okay? So, make sure you understand what your state dictates. Are you a one-party or are you a 2-party state for recording? Let's talk about these 4 privacy rules on slide 34. Okay, first, don't intrude into private areas, locker rooms, desk drawer, dressing areas. No inquiries about sexual orientation, okay? Remember, private areas are private. I don't think this is difficult. We would not logically allow cameras in a locker room, okay? And talking to people about their sexual orientation unless they bring it up and say they want to talk about it. 2, don't disclose private facts about employees without permission. Companies need to be very careful about protecting individual employees' information, private information, okay? HIPAA is a good example. You don't need to discuss people's medical situations, prescriptions, things that they would not want to disclose to people. And companies are entrusted with a lot of this. 3, don't portray an individual in a false light, allege criminal activity. Even though we have the Fourth Amendment, which is, your freedom to speak and that, let me tell you, the First Amendment, the right, freedom of speech, Fourth Amendment, which we talked about also. But you got freedom of speech until one thing happens, until you say something that is false and that could damage their reputation or monetarily damage them. If you say something on the internet or in person or convey to someone else that is false and can cause reputation damage and or monetary damage, that does not give you the right to speak, and you can be challenged both civilly and criminally for that kind of action. All right, and don't use an employee's name or photo without obtaining consent first. All right, so once again, companies have employee photos, they have different things. You need to get consent when you start to use things that are personal to that employee. These privacy rules are very important to follow. Some companies think that because they have the information in writing in a file that's in a company file, that they can use it, and I'll say abuse it any way they want, and they can't. Slide 35, we could talk about all day, social media. Hacking into a private social media or email account versus a public account. Let's just make this simple. Social medias have public accounts and they have private accounts in every single one of, these types of social media. You can go to Facebook and there's public and there's private. Once again, if a company hacks in to any private section of a social media, that is improper, and you could be criminally and civilly prosecuted depending on what you do with that information. So, understand in social media, if you're in the public account area of that person's social media, there is no expectation of privacy. That information is a free-for-all. If you're in the private side, it must be treated with respect. So it's very simple in the social media what you should and shouldn't be doing. File 36 here, slide 36. Background and credit checks. Bottom line is you always need to get a sign-off when you're doing a background and credit checks. Credit checks are not public record, okay? So you cannot use credit information in a public, unprivate manner. You have to get permission, and you should. And many times a company needs to know information on the credit because this person is handling large sums of money, cash. They're a cashier, they're a payroll person, etc. So there's a reason for checking their credit. Slide 37, peace method. A relaxed and comfortable person will cooperate with the investigation and tell the truth. Give respect, you get respect back. slide 38, we're going to get into why would an employee investigation fail. There's several reasons. Let's kind of review a few of them. Slide 39, we can start with some of those common investigation mistakes. Failure to plan your investigation. You don't have a game plan of who you're going to talk to, when, and how. You're ignoring complaints. You only listen to who you want to listen to, not being universal on that investigation and being objective, okay? And delaying investigations. This is important. A lot of times companies delay it. Information, facts get old, get lost, and don't lose your objectivity. And we also got to fight. You don't want to become distracted during the interviews. Stay focused on the objectivity of the investigation. Don't delay it. Don't ignore complaints. Listen to both sides, all sides, and don't lose your objectivity. And once again, don't get sidetracked. This is important. Other ones, sometimes investigations are being conducted and the person is just being overly aggressive in the interview. And that is why a lot of times when it's an internal investigation, and I think involves something anywhere near seriousness or complexity, I always like to recommend outside investigation services, those that are trained, those that do it for a living and can be objective, to come in and do the investigation. Many times workers, it's easier for them to talk to an outsider than to talk to someone who's internal to the company, because that person is always going to have that information, and the employees are hesitant to share, as much. A side note here, we're seeing a tremendous amount of use with 1-800 hotlines, where employees can call in and provide information on these hotlines. Without a doubt, there has been a significant increase in information, valuable information, coming in through 1-800 hotlines because people are hesitant to tell someone direct at the company. Once again, some other mistakes. You want to be careful that you don't conduct a thorough investigation. Make sure it's thorough. The other thing is, let's reach a conclusion. Many times, no conclusion is reached. It's left open. And also, you need to have a written report because you may need to come back to that. You may need to come back to that if other incidences happen. And let's say you do a written report, and over the next year and a half, you do 3 reports, or 3 different supervisors do a report, but they all point to the same person with the same problem. And without the written report, it becomes hard to track and to bring those reports together for a common cause of identifying a problem. So always create a written report. Always try to have a conclusion. Be thorough. And we see a lot of times there's failure to follow up. You talk to the people involved initially, and when it's all said and done, it's important to follow up with these individuals and say, here's the conclusion we came to, I came to, the investigation came to. You owe respect back to come to a conclusion on those issues. So, surveyed companies state that more than 25% have fired employees for misusing inappropriate email content or internet usage. This comes from ABC News. We're seeing a lot more what we believe misuse of employee time with the internet and other aspects, and we're seeing companies monitoring this, documenting it, investigating it, and about 1/4 have fired employees for misusing it inappropriately. Email content and other internet usage. So we are seeing some serious cases. This also supports the fact that it supports companies and management's cause to say this is why we are monitoring more than we ever have in the past. Number one, because they have better monitoring tools, and 2, because there seems to be a need for it, and they go from there. In the end, your company will be known for your ethics and integrity. We've got to be careful that your electronic surveillance doesn't get to the point where you cause it to really violate and affect in a negative way the company ethics and the company integrity. I encourage all of you, it's a balance between obvious productivity, proper monitoring and everything, but we need to make sure that there's a balance between what you do and the culture of positive that it can cause, or the negative culture that it can cause. We're going to stop there and take some more questions. I want to thank you, everybody, for listening. So we have time for a few more questions.
Thank you, Tim. If all the attendees can enter in the passcode for today, which is privacy, and any questions that you have for Tim. And in the event of time, if there are questions that are not answered, they will go directly to Tim to follow up with you individually.
Yeah, and I want to reemphasize there, everybody, you'll have my email. You email me a question, not only today, but anytime in the future. And as part of participating with TASA and the TASA support, I will get back to you. I will give you an email. If you need a phone conversation, feel free to let me know in that email, and I'll call you back. Once again, there's no cost. This is part of the TASA package to reach out to thank you for today and for being a client. So, questions. Let's see here. All right, let's see. What if the camera with audio is pointing directly into an office and not just surveilling the hallway? Once you have audio capturing, it doesn't really matter where it's pointed or what it's doing. You need to notify all employees on the audio that you have cameras that are capturing both visual and audio, so that they understand there's no expectation of privacy, and that includes anywhere near where that camera is. Instead of trying to figure out whether, can it listen all the way down the hall or to the right or to the left. Once again, with audio, you need to have full disclosure, and you can't cut corners with it, and it's not smart, nor it's going to lead to problems. So you need to just notify that it's happening and go from there. Social media accounts. What about requiring employees to provide the employer access to the social media account, adding as a friend, or in some cases requiring the employee to provide passwords for access to social media? Great question. This is a huge debate right now on whether the company can ask an employee for their password to monitor their site. Right now, the legal debate, once again, I'm not an attorney, but the debate that's been going on out there and the repercussions and the response to this has been simply that courts and legal battles that have been fought out there are coming back with the fact that basically a company has no right nor should be able to ask an employee for their password to their personal sites. Now, if you're talking about a company site that's created by the employee that is strictly, obviously, a company social media site or a company whatever, that's different. But I think this question is pointing to the fact that someone has a personal social media and the company wants the password to go in and take a look around and kind of size them up. bottom line is, if it's your personal and private company, I would tell you so far that has been met with resistance and negativity. And the only time you can give a password, or should have to give a password, is if it's a total company site that you're just working on as a company employee. So, and that's been a big problem, and it started out usually in the hiring and interviews is where people were asked for their personal passwords to look at their personal social media sites, and that pretty much has been stopped. Okay, I don't think we have any other questions there, Rochelle. Once again, everybody, feel free to contact TASA or myself. We'd be glad to get back to you, and thank you all for participating.
Thank you, Tim. And just a reminder that all certificates will go out via email in 24 to 48 hours after this presentation. I want to thank everyone for attending, and most especially Timothy Dimoff for his time and effort in creating this presentation. If you would like to speak with Tim, or if you would like to speak with a TASA representative regarding an expert witness for a case that you're working on, please contact TASA at 1-800-523-2319. One of my colleagues will be following up with you regarding your feedback on today's program. Again, thank you all for attending. This concludes our program for today.
Hello? Hello, anyone still there? Hello?